Hello.
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 Hello, bitches.
Hello. All rise and like, subscribe, and bang the gavel, baby.
Order in the court, I say. Happy Monday. We got a case back at it. 2 hours of live courtroom action and drama. Myself, Creedence, and Mikey the Legend. Do you notice anything different other than me being a year older than the last time you saw me?
There's an empty chair in jail first floor.
No, I got a new camera I bought for my birthday.
Very nice.
So hopefully we're not going to have this, like, look, I'm moving around and stuff, and Bob Ross doesn't even need to be in there.
Do you expect this to be the end of an era? The end of the Creed frame?
Nah, I don't think that had to do with the Creed frame. You never know. Jules, great to see you. Sergeant Buzzkill. Flush it with a big warning.
The biggest of all time, from what I can see.
The Jerry stuff. Hope, in the words of many of you now, this is too funny to me. Hope everybody is level 1 outstanding today.
I like that we're getting the inside look. First floor jail, way nicer than what appears to be the second floor jail, where you have to talk on those really weird phones. That kind of thing.
Hey,
waiting in Australia.
Australia, you say? Anyway, so we got a case. We're going to jump right into it. Where's Pierre?
God bless Australia.
We'll be jumping around a little bit here and there. Court's pretty active at the moment. We left Andrea the other day, and she was very confused and still is very confused.
She's very stoic every time we see her. Oh, by the way, Creed, I want to mention, welcome anyone watching over on the We Gotta Chase YouTube channel. That's right. It's a YouTube channel strictly dedicated to We Got a Case. So if you happen to be over there today, thank you. Please like and subscribe, because it's going to be a wave of a day.
Wang, good to see you. Let's jump into it.
Attorney at law, Mr. Grip, back in.
Does Judge have one of those Judge Judy filters on her face right now?
I think she's just really pale, and there's bright lights in there.
Ain't been out in a while. Grip, we're familiar with him, ain't we?
Grip will set the table.
45 months community custody. The DOSA evaluation was lengthy. It indicated that there has been long underlying substance abuse issues.
So we were a couple minutes late. So
they have probably contributed to some degree of his recidivism. Although this is his first VUXA offense.
Recidivism?
There was a notation that he does qualify for level 3 residential treatment, but given his long criminal history, his offender score, and
offender score, that's something we've learned about.
Own impulse control
recently.
I think that the prison-based alternative and a confinement portion would be more appropriate if this treatment is going to have an effect on Mr. Smith's outcomes.
We're talking to the dude that's sitting in the court, by the way.
I have read your statement, and what additionally would you like to add to that?
I don't think I can add anything further, Your Honor. It was written before the formal DOC statement on the drug offender sentencing alternative had been issued. I would like an opportunity for my client to address the issues that are at stake for him.
Just
any
Ashley.
Time imposed.
Ashley
wants a period in which he can gain rehabilitation, get back his life in a good way.
Thank you, Amy.
Best as possible.
Hey, Amy.
The court has its discretion about the type of DOSA to impose. If he makes such a decision on that matter, though, he'll probably want to address the DOSA issue. Alternatively,
is he saying about a ghost?
Is not something appropriate.
DOSA?
The lowest end of
they said ghosta.
I'm not sure.
Your Honor. Mr. Smith may have comments about the DOSA.
All right, just 1 second.
I was going to ask Judge if she likes Hot
Chance to
Topic.
address the court.
She's very gothic.
Thank you, Carrie.
All right. Mr. Smith, what do you want me to consider before I impose sentence in this case?
Just let him out.
Please let me go.
Over and over, I have been put through the courts for DOSA. I've had this.
Level 1, but not outstanding. Vicky, I love it.
Vicky, good to see you.
I truly don't believe that my problem is drugs. I believe it's a mental issue. And I've been asking and asking and asking for mental help for the courts for years.
Happy birthday, Miles.
Happy birthday! Arrested more than 6 times growing up.
That's a lot.
Recently, it's happened again since I was here in the jail. I had an issue with somebody trying to crawl into bed with me in the middle of the night.
Wait, what? That's scary when you're in jail.
I feel that my mental issues.
I just want to
is giving
cuddle.
me a serious problem with.
I just need to be held, Your Honor.
Communicate and function properly in the community, and I'm just afraid that if I go back for another drug sentence, that I'm not going to get the proper help that I need.
So he wants to be put into like a treatment facility instead of the old Stony Lonesome.
Years old.
Yeah.
I've just been asking over and over and over.
Hey, old buck.
Almost my life. Help me, help me, help me. I'm an ashamed man.
Do you think that's true?
I can't come out and just talk to people. You don't know.
I would say that if I had a chance to go to rehab or to jail where somebody's going to chase me down, hold me down.
Now working for me.
Hey, Gina.
She comes in and sees me. She's been coming in and counseling me through this and trying to get things taken care of. I've also talked to
Nap time. You a toddler?
Jennifer from Community Action, trying to see if there's a course of action that I can take so I can get some kind of mental help.
Do you think Judge Paul is doing his nap right now? That's why we got Judge Slavio Boya.
I don't want to be in this predicament again when I get out, or if there's a way to get me into some kind of help. Now, like I say, I've been asking Mr. Grip. Mr. Grip has been very, very helpful for me, trying to get me into programs. Like I say, I've been denied because of various reasons.
By the way, Creep, my son is applying to a company that Vicky works for.
And
really?
But here in North Carolina, she's
trying to live a normal life.
That's kind of cool.
Financially dependent. I have my Social Security, which I haven't been able to collect any of it yet.
Well, then you don't have it, bud.
It was granted to me. I'd just like to get another fair shake at life.
A dude that doesn't have a problem with drugs, it's more mental.
You believe that your mental health issues are
drug related.
Issue, but do you agree that you also have a substance use issue?
Excuse me.
Your Honor, I don't use heroin. I don't smoke marijuana. I don't drink. I don't do pills unless they're prescribed.
What do you do then?
Go off my outer wall.
He's going to be a little low, Wang. Let us know if that's
street drug. Yes, it is, but it's also the same derivative of what I take. I don't do any other drug. Period.
I can't crank him up anymore.
I've never done heroin. Never done cocaine. Never smoked pot.
Bragging.
I don't understand what my drug problem is, other than I go back and use street meth when I can't get my prescriptions filled for my Adderall.
All right. So, Mr. Smith, this is what I'm going to do. I'm going to set your sentencing over 1 week. I want to see the DOC report because you're telling me you don't have a drug issue, which if you don't have a drug issue or you're not willing to address it, the court's only real option then is to sentence you within the standard range to 60 months and a day. And so I want to see what DOC has to say. And so I'm going to set sentencing over 1 week. And I'll see you back next week. So, Mr. Grip, if you could put another copy in my bench copies, I would appreciate that.
Absolutely, I can do that.
What did Grip whisper to you, Creed? I saw him whispering to you.
Mr.
I don't know.
Thank you.
That's kind of
Right. Who is on the jail?
again here. it seems as if they don't really want to help him, huh?
It seems like they don't believe him, Creed. There's a difference.
Today,
They might be
21-1,
willing to, but
457-14.
Jeffley was
and
not looking to
22-1-86-14.
help him just on his shaky voice plea.
So the 22 cause number is on for arraignment. Mr. Festi, are you ready to address arraignment?
Your Honor, that's.
Yeah,
Yeah, you're gonna have to be linked to it,
Correct.
so it'll start popping up.
And will you just make sure you're at that microphone, Mr.
Excuse me,
Festi?
yes, Your Honor, I had a chance to meet with Mr. Smith Friday. This time we waived formal reading of the information. Enter plea of not guilty.
Do you have a link for it? You can
Set
I'm
date.
getting it right now.
All right.
I believe there are discussions.
On the way, Glenn.
Looking at ways of resolving this case, but for now we need to set dates until we have further information to reveal to the court.
All right, Mr. Jackson, anything you want to add?
Weathered.
Not really. I know that there's going to be at least one more referral coming in from Montesano PD, maybe a second one. So I'm trying to expedite those to get everything on the table as quickly as possible. But no, each of these trials will be 2 days.
Well, when
All right,
Steve
so
talks,
the
you can tell
22
how
cause number, I'm going to
cranked
set
up it
trial
is.
for Tuesday,
Mhm.
May 10th at 8:30, trial readiness for May 2nd at 9 o'clock, and omnibus for April 11th at 9 o'clock. The other matter is on for status. Mr. Festi, did you want to address anything in the 21?
remember, if you ever see anything good, timestamp it or link it and let us know. We can always go back and watch it, Crystal.
Knowledge that Mr. Smith had interest in the drug court program, and Mr. Jackson is open-minded to look at that, but such would be.
He's open-minded. He'll try anything once.
Further investigation. So those are all. Have to be-
Good point, Finney. That dude that we just watched may have
All right,
done a
I'm
lot
gonna
of
leave
crazy
bail set
crap. You know what I mean?
both
Like that.
matters at this time. Mr. Smith, if drug court is something you wish to be considered for, then you and
Like-
your attorney need to get that application.
Like
in
that
as
quick.
soon as
Here you go. Here's some
possible.
help, dude.
There's some
Mhm.
pieces of information they need from you. And Mr. Jackson can make whatever decision the state is going to on their position on that. So anything further for Mr. Smith today?
The 21 cause number, we're just preserving all
Yeah,
the.
they're boring,
other
but what do you
dates,
got?
Correct.
I did have, which is now going away, I guess. This was going to be a good one. I felt like these are misdemeanor court.
Oh,
So they're bringing in these people, getting their whole thing set up. This is the assistant attorney.
interesting.
I'm guessing they're going to jump back to this soon.
All right.
But I'm
Keep an
keeping
eye on it. We've got landlord-tenant matters over to 3B with old Middleton.
Did you say landlord-tenant matters?
Somebody is renting it is, and it's not in my name, and it's not in anybody else's name. It's in somebody else's name.
Oh, okay.
Bigfoot, always with big issues with his landlord-tenant matters.
Yes. That's who I thought of when I thought of landlord-tenant.
Did he end
Always
up
an
burning
issue.
one of his places? That's what he's in jail for now, I guess.
He did. It is.
It is. Hey, Charles.
Landlord-tenant.
Even Jeffrey smokes a pot.
Good
I'd be
afternoon,
surprised
Mr.
if he
Johnson.
didn't.
Can you hear me?
Yes, but barely. Pot it up, dude.
It is
Judge
cranked
Nelson.
up completely. So if
Always
you're-
low.
always low. Nice drink.
Hey, Drake, what's going on?
And it's moving slow
Good
as usual.
afternoon, sir. Can you hear me?
I can now.
Very good. Your matters are set for 125 for your first one. Then there's one in the middle and then your next one. We had a 115 case that's been dismissed, so.
Wow, he's got numerous cases on the docket in one day.
YouTube feed on, we're on Zoom and we're being recorded. So let me put you in the waiting room, I'll bring you back in momentarily.
While he fumbles around with that, so you found some magistrate stuff, you said, right?
Yeah, and it seems like they do some of that stuff on Saturdays. So it's going to be one of those things where we're going to have to keep an eye out with these
I like-
court proceedings.
I like the magistrate stuff because if I'm not mistaken, those are the people that like got arrested overnight and seeing them at first. So you're going to hear all of their charges, what they were brought in on.
They're
and
going to
probably-
decide what their bill's going to be, if they're going to get bill at all, and they're going
Yeah.
to hold them. You know, they have to make all the decision what they're going to do with these people.
No, I like that.
Y'all have to excuse me as I go through tons of courtrooms right this second.
Yeah, I was going to say, if you find something, we'll pop over to it because I bet.
Tick a little bit. I was hoping maybe somebody would come around and we could start early.
We'll just start with your 125 then, unless everybody else isn't there, probably.
I found a courtroom, but I have no idea what's going on here.
Well, let's jump over and see it. I'll keep an eye over there.
Definition and the evidence that supports that. So for purposes of that argument, the motion to dismiss.
I've seen a
is,
few things with this
really
judge.
a motion to quash the information. And so
Very small
my
courtroom.
role as a circuit court judge is to review the
Thank you,
district
Glenn.
judge's bind over decision. The case law establishes that at the prelim, some evidence must be presented regarding each element of the crime.
We
or
just
from which
dump it
was
in there and it
not
sends it out to all the different
circumstantial evidence along
places
with
we're
reasonable
on.
inferences arising from that.
Oh yeah,
and
it goes
suffice to show
everywhere.
probable cause. And I'm to review the district court's bind over decision for an abuse of discretion. And a court abuses its discretion when its decision falls outside the range of
I've
reasonable.
never seen a judge have a
outcomes
doorway behind them.
or makes an error of law. And I think
Like,
here we have a
watch out, Judge, there's
question
someone
about the
behind you.
legal definition of
I'm pretty
private
sure he's in
reputation.
court too, JJ.
When we're looking at determining the scope of a criminal statute as a
By the way,
matter of
this is
statutory
53rd
interpretation,
Circuit Court.
that is a question of law. And therefore, my review of those questions is de novo or anew, meaning that it requires no deference to the ruling of the district court on those
Heck
legal
yeah.
questions. In this case, there are some
970
undisputed
to go.
facts
Ha, Carl.
as I reviewed the preliminary examination and the motions. On October 14th, 2021, sometime shortly after 3 p.m., defendant went to
So-
the superintendent's secretary's office.
We're watching a
There
big
is
case
a
here.
door to that office that is typically closed but is unlocked.
Could be.
Uh-oh. Go
Parents
on.
and other visitors typically go into that office, which seems to serve as a reception area of sorts.
Okay.
Usually, but not always, a secretary is present at a desk to greet visitors.
I'm
On
guessing
this
that's the
occasion,
secretary.
secretary was not present. She had apparently left earlier than the typical end of her shift.
Something happened.
Testimony from a school board member at page 28 of the transcript was that people come and go out of that office. Now, the superintendent has a separate office that is about 10 feet down a hallway from that reception or entry area. He was having an unscheduled meeting that afternoon with a school board member in his office. And he agreed during his testimony that during that meeting, quote, "You're about 10 feet down the hallway, no one's in the secretary's office, and anyone can come in there physically." That was
Oh,
at
some
page
got
20.
stole.
He said, yes, agreed.
According to the
The
CDC,
defendant waited
pretty
for
much
some
that.
time in that reception
Where are
area,
you, Benton?
and it's quite evident that she heard a conversation taking place in the superintendent's
I haven't
office
seen a mask in a while.
between the superintendent and a school board
Thankfully.
member. Surveillance video from the school suggested that she had recorded that conversation. So a search warrant was obtained and an examination of her phone confirmed the recording. And that she recorded the conversation from the secretary and reception area. Those appear to be undisputed facts in the case. One disputed fact from the preliminary examination seemed to be, did the defendant go down the hallway to record? And Mr. Wisely acknowledged if she tiptoed down, stood outside the superintendent's
All right,
office,
so we get this lady who's
conduct would,
recorded this
not be
conversation,
protected and could well violate that statute.
which they aren't allowed to. It's
In a
against the law.
trespass letter from the superintendent to the defendant, and this was attached to the defendant's brief. That letter said, quote, "You walked down to the office, stood outside my door, and began recording a conversation."
Uh-oh.
The impact statement of that same superintendent attached to the prosecutor's brief states that the defendant, quote, "took it upon herself to walk down the hallway and record just steps from my inner office door." If that
The
were
inner
what
sanctum.
happened, Ms. Chasky would clearly have violated this statute. The bad news for the superintendent's statements is that there was absolutely no evidence or testimony to support those assertions. The superintendent did not testify about where the defendant was standing while making the recording.
He did testify she was nosy as hell.
Was that he didn't even know she was there. How does he know where she was if he didn't even know she was there? Deputy Schmolt reviewed the school surveillance video, and he testified on direct exam that the defendant, quote, had also stepped into the hallway, which isn't covered by the surveillance camera. That was at page 33. But on cross-exam, Deputy Schmolt wisely walked that assertion back. He admitted that from the video, he cannot see whether she walked into the hallway. That was at page 44.
Because the only ones that wear them in that are the ones
so
that are
she's
fresh.
Standing in the public area, but never crosses into that hallway. And he answered,
Got
at
it.
that point, there are points and times where I can't confirm that. And then the deputy admits that there were no points and times where he could confirm from the video that the defendant even entered the hallway.
Can we see in the video of her tiptoeing?
I would love to see
despite
that
some of the
because I
statements
see
that
her
were
sitting
made
there.
by the complaining witnesses,
Not
there was
bad.
no evidence to support those statements at all about the location of going down the hallway. The only evidence presented in this case thus far is that the defendant was standing and located in a publicly accessible and publicly utilized secretary's office and reception area.
What do you think she was recording?
That the allegation
A
that she
conversation
walked
between
down
the
hallway
superintendent and another
to record
board
the
member.
Conversation from just outside the superintendent's door, that those assertions are not supported by any evidence at all.
Was she trying to blackmail somebody
So
or
now
something?
we look at what is the
That'd be
offense
my guess.
charged. She's charged with the felony crime of eavesdropping. Now, when you hear eavesdropping, you might think about what your
Felony
impressions about what it
eavesdropping.
is. But it's a very specific crime.
Wow.
This is not the same as what people might casually or commonly consider to be eavesdropping, such as unintentionally listening to an overheard conversation. That's what when we say they were eavesdropping, meaning they were intentionally, that they were intentionally listening to a conversation they could overhear. That's not what this statute addresses. Rather, there are specific elements and specific definitions that must be present to constitute criminal eavesdropping. And the statute at issue is found at MCL 750.539C. And it provides that, quote, any person who is present or who is not present during a private conversation and who willfully uses any device to eavesdrop upon the conversation without the consent of all parties thereto is guilty of a felony.
I knew it was illegal, but
Now, the
I
statute
didn't know that
also
was
it's a felony though.
That'd be like recording anything out in public.
overhear, record, amplify, or transmit any part of the
Thank
private
you, little
discourse of others without the permission of all persons engaged in the discourse. So in the elements and the definition, it talks about private conversation, private discourse.
Yes. I think
That's
so,
really
right?
No, the
only
secretary
element
had
that's at
left.
issue in this
Yeah.
case.
That's what I mean. It's
is
secretary
whether
that
the
wasn't at her desk.
conversation was a private one. The statute does not define private conversation. That's a problem for us. It would sure be nice if they had, since that's one of the key elements, right? But it does define private place. The definition of private place at MCL 750.539 A1 is this: a place where one may reasonably expect to be safe from casual or hostile intrusion or surveillance, but does not include a place to which the public.
What
or
the hell did she
substantial group of
record
the
that
public
has caused such a
access.
hubbub?
Gotta be something
That makes us
good.
think
Yeah.
about what the definition of
She
private
must have
conversation
sent
could
it to
be.
everybody she
The
knew.
Michigan Supreme Court in 2001, in the People v. Stone case, they did in fact apply that private place definition to the question of what constitutes a private conversation, and sensibly so. And in People v. Stone, the court held, quote, thus, private conversation means a conversation that a person reasonably expects to be free from casual
Yes,
or
Ben.
hostile intrusion or
Loud
surveillance. That's at page 563 of
I-
the Stone decision.
I think so. Could be
Now,
wrong.
since the court in Stone applied the concepts from the private place definition,
Yes.
it seems to me that
think
the
so.
exception in the private place definition would also apply. Thus, a private conversation does not include a conversation to which the public has access. Although, frankly, that really is part of the question of whether there's a reasonable expectation that the conversation is free from intrusion.
Okay, here's the question I have,
So both sides in this case have sometimes used
which I'm going to
phrase-
pause this just 1 second. If they're he's the superintendent of the school system there in that area. If he's in his office, aren't those offices then public areas because they are, servants of the county or the city or the state? Would they really, those are, a taxpayer owned area, we'll just say. Does that really constitute it being a private sanctum?
This one's interesting though. I
Can we
don't
get law talk with Mike here so I can ask him? He would know.
Where's Mike?
Can we bring him on?
reasonable expectation of privacy as a shorthand for this concept. And although it's not legally identical, it developed in other contexts as an analytical shorthand, that generally does the trick. So we're really looking at, did these parties have a reasonable expectation that their conversation was private? And so in the Stone decision, the Supreme Court said that their definition of private conversation was consistent with their previous ruling in the Dickerson case in 1999. And in that case, the court said that whether a conversation is private depends upon whether the person conversing, quote, intended and reasonably expected that the conversation was private. So that's the reasonable expectation of privacy. And in Dickerson, the Supreme Court noted that the proper question is whether the conversation itself, not the subject matter, was intended and reasonably expected to be private. So the specific subject matter of what was being discussed is not relevant for purposes of the statutory analysis. Now, in Stone, the Supreme Court held that generally, whether a conversation is private is a question of fact. And so the prosecutors argued that this means that I should deny the motion to quash and allow the jury to determine this question. But in 2011, in the Bowens case, that's 489 Mish 850.
I was gonna say there has to be a few cases or
it's an
something that you can fall back on.
In that case, the Supreme Court recognized that although that's generally a question of fact, the court can decide the matter where the issue was not reasonably in question. In that case, it was the context of summary disposition in a civil case. And in that case, the conversation was being held backstage before a concert where people were coming and going. And the Supreme Court said that conversation was clearly not private, despite the party's subjective intents. And in fact, it was so clearly such that even though it's generally a question of fact, it's not a question of fact when it's clear. It also bears noting that the Stone and Dickerson cases that apply the statute are very different from what we have here. In Stone, a neighbor used a police scanner to record conversations that a woman was having on a cordless phone.
Oh.
In Dickerson, a parent's conversation with a child was surreptitiously transmitted by hidden microphone. Here, by contrast, a conversation was overheard by someone who was in a publicly accessible location, and she recorded that conversation. The defendant is alleged to have used a device, here her cell phone, to record the private conversation of the superintendent and a school board member. It's notable, she's not alleged to have used any device to amplify that conversation or to capture it from a distant position, like using those parabolic microphones from across the street or something.
Stuff from like a spy movie.
Also to have captured the recording through the installation of a secret recording device in the office. Rather, she's alleged to have recorded a conversation that she overheard with her natural ears. The conversation was taking place inside the superintendent's office with the door open, and she overheard with her natural ears.
Hold
and
on. The
recorded that
door was
conversation
open?
from the publicly accessible secretary's office just down the hall.
Come on, man.
The prosecution suggests that the defendant was not entitled to be in that secretary's office at that time, but the evidence does not support this idea. The testimony was that the public comes and goes from that location. It is where visitors frequently report for assistance. This conversation took place very near the end of the school day. It wasn't like 9:30 at night or 10 o'clock at night. Maybe it'd be different. There's been no evidence presented that the defendant was somehow illegally in the school, or that she was in a location or at a time where members of the public would not be there on a regular or intermittent basis, or where they'd be allowed. So on the question whether the conversation was private, the district court and the prosecutor are focused on the locations where the conversation took place. And the district judge stated at page 53 of the transcript, quote, "Clearly, the superintendent's office is not a place where the public or substantial group of the public has access."
I'm no lawyer.
That statement's absolutely true. The superintendent's office is not open to the public. But I do believe that the district judge and the prosecutor were focused on the wrong place.
Wrong
The
place,
proper
wrong time.
focus is not where the conversation is being held, but it is the area from which the conversation is being naturally heard. So long as no device is being used to amplify it or to capture it from a distance, like a parabolic microphone. For example, my
Does the
judicial
judge have
chambers
stock in
are
parabolic
certainly not
microphones?
accessible by the public.
Twice.
Under many circumstances, I would intend and I would reasonably expect that a conversation I'm having in my judicial chambers would be private. But it depends on the specific manner and circumstances of that conversation. If I was conversing, now my chambers in Sheboygan has a hallway that leads to the public hallway and the door is closed. If that door, which it sometimes is open to facilitate transports of prisoners or whatnot, if that door is open and I'm conversing and somebody standing in the public hallway can hear it with their natural ears, I would not have a reasonable expectation of privacy. Or even if the door was closed, if I was arguing with the lawyer in chambers, if I was speaking so loudly that I would know that somebody could hear it in the public hallway, same thing, I would have no reasonable expectation of privacy. So again, I think the critical question of the place is not where the conversation is happening, it's where the hearing is happening, or where the overhearing it is happening.
It's not like
And
she
here,
put her phone
the
in his
participants
office
to
and
that
hit
conversation
record.
took no steps
That's
to
where he
ensure
keeps saying
that
about like
nobody
the
was in the reception area.
Yeah.
pause that real quick.
They did not
So the
close
parabolic microphone and how I say so. I mean, you could say that if somebody was using that,
Yeah.
they had a reason to be there to spy on somebody, basically. You know what I mean? But I totally understand.
The door is
coming
open.
from. Yeah,
They're
I mean,
talking loud enough to be heard into a public
right.
area.
Like
I mean, come on, man.
yeah.
Again, there's nothing being done that would, to me, say, okay, this was an intentional, malicious thing they did to try and sneak and hear what was going on.
Right. And that's why I think that's why he keeps going back to that, though, to
He
kind
has to throw this out, right?
Yeah, to point out that I mean they were not there intentionally to catch all of this on tape.
It must have been juicy, whatever it was.
It had to have been. Whether it would be like
salacious, some would say. Creed.
It had to be a great conversation, no matter what. No
you
matter
think
what was going on. I mean,
you think she lost her job?
Might have. Bill,
If so,
great to see you.
we'll be back for that lawsuit. Sheboygan.
The door. The testimony was people come and go there. So they should know that people come and go there. They even said, yeah, people could be there. They're not prevented from being there. And the conversation was heard by this defendant who was standing in a publicly accessible reception area, only about 10 feet away or so. Under those circumstances, I would find that the conversation was not a private conversation for purposes of the eavesdropping statute, as that term has been interpreted by our Supreme Court. For these reasons, I would treat the motion to dismiss as a motion to quash the information and grant that motion. Now, the defendant has also raised, frankly, interesting constitutional questions about the specific context of this case, in which a citizen is seeking to hold governmental agents accountable, and the government then comes after the citizen. Now, at this point, both sides
So she didn't even
have
work
raised
there.
some very good points on those issues. But this court, part
Yeah.
of judicial restraint is to only reach constitutional questions when you must. So there's no need to do so at this juncture because I'm granting the motion to quash. So I'm not going to reach those questions. The defendant argues that the case should be dismissed with prejudice. Certainly, if I did reach the constitutional questions, that would be. But quashing information is not the same thing as a dismissal with prejudice. Rather, it results in a dismissal without prejudice. And because the question answered by the district court was whether there was probable cause to support a bind over to the circuit court. I have held that there was not, based on a legal interpretation of the eavesdropping statute. Therefore, the case will be dismissed, but the law would allow the prosecutor to refile and present additional evidence if they believe doing so is warranted. However, in People v. George, 1982, the refiling of charges after a motion to quash has been granted. It does not implicate double jeopardy, but it can in fact raise due process concerns if merely the same evidence is presented. So there would have to be some new evidence, like we found out she did tiptoe down the hallway and stand outside the superintendent's door or something like that. Otherwise, the case would.
So they don't have video of her
not be
tiptoeing
allowed
down
to
the
be
hall.
brought.
0.0
Therefore,
video of
this
her
case is
tiptoeing.
dismissed. The defendant is discharged in this matter, and I do have an order granting a motion to quash and dismissing without prejudice, and I'm signing it.
Quashed, my friend.
Thank you, Your Honor.
All right, thank you.
That was an interesting one. I didn't know if we were even going to see the end of it because.
Yeah, I was curious, but yeah, they didn't play around. They went in, they did their job.
That's
again, you know, if
pretty
you got a
interesting.
private conversation, close the freaking door.
Yeah, no kidding. Over to 3B with some landlord-tenant matters and Mr. John Barnes.
Yeah, we were disqualified for, we were over like $200 according to Keystone.
It's illegal if you're going to spy on somebody who's handsome. Apparently, you could be felony.
Yeah.
No, that's fine, and I should have it. I should have it caught up by then. I
April 18th at 2:30.
Okay.
Now, if you do pay it all by then, Mr. Dotson knows he can simply.
I'll leave you on this for just a minute. I'll be RB.
Go ahead.
This is also income tax refund season, and perhaps there'll be a tax refund or something which will help you pay this. And then your rent.
It's tax refund season, everybody.
But we're going to continue this as it is a non-payment of rent case with personal service for 30 days.
Why can't I hear anything?
Which would be April 18th.
You'll get yelled at.
And, so you stay in contact with Mr. Dotson in the meantime. And, if it's paid, the matter will be dismissed. If it isn't paid, we'll discuss it further on the 18th of April. And if he gets what he asked for, you would have until April 28th to move out, pay the rent, or be subject to being evicted. So it sounds like
understand.
You've made some significant payments on it to get it caught up.
Can we get Charles some lights?
All right, Mr. Dotson, anything else we should put on the record here?
Not that I can think of, Your Honor.
All right, continue these both to the same afternoon within 15 minutes of each other. They will be by Zoom like this once again. Mr. Sonneville would be happy if you could come in with Zoom, but we'll cross that bridge when we get to it. I will see you on April 18th at 2:30. Stay in contact with your landlord.
Thank you.
All right. Thank you.
Yeah. Madison keeps coming in there yelling like that. She's gonna get her ass. Her feelings hurt real quick if she don't be quiet. come in court yelling like
John, I
that.
actually skipped ahead. Your case was in between those two, but I wanted to finish both of those matters. And besides, Madison Payne hadn't logged in until just a minute ago, so.
Madison Payne taking her
Erica Kelly, though. I'm on my daughter's computer.
All right, it's Erica. I talked to her the last time, so same thing.
Oh, she got a lot of good stuff behind her. She got a closed basket, which appears to be holding a box. So it's a box basket. Not sure what that other stuff is there behind her.
All right, let's talk about this case. It's entitled SNL Property Solutions.
SNL?
It says
Saturday Night Live?
William Payne and Erica Kelly Payne. Ms. Thornton, who is the property manager for the SNL Properties, is here. Mr. John Barnes is here. When we were here back in March, William was in jail.
Be sure to like this video if you like William being in jail.
All right.
Uh-oh, who's he calling? The jailhouse?
Hello, Deputy Bradford. Sorry to bug you on short notice. We got a landlord-tenant case, and one of the parties is in jail. Could I see William Payne via Zoom?
Yep, right over now.
All right, thank you. Bye.
Wow, look at that.
Zoom and Polycom is a blessing for our inmates.
It's also a blessing for people that don't want to have to show up in court.
I don't completely understand. I don't have Amy.
Scott is a very nice looking fella.
Some issue, but this is a termination of tenancy.
Scott has the kindest face you've ever seen.
So it's not a keystone matter.
I'm not sure, but I do have information. Keystone did send some information, and
Well, don't do too much till we get William here, so we don't have to do it twice.
William's coming. Let's get William moving. Don't forget, guys, mini Chase Monday coming up today. We got a chase. We've got a lot of cool stuff, including a boat chase that was sent over by Vicky. Vicky. That's right, Who's Handsome. And there is now a case-only channel. We got a case where these amazing cases will be streamed every single day, Monday through Friday. Sorry for the barking dog. My son is going to a job interview, so he's leaving the house. Hopefully he gets it. This will be a new job for him. When he was downsized from his other job, basically. So we'll see. Fingers crossed on that. While we're waiting for the judge to bring in that dude, I'm going to show you
Before filing your
courtroom.
complaint, let me back up a little bit. Are you the plaintiff in this divorce case?
Yes.
It's a
And before
divorce.
filing your complaint, had you been a resident of Wexford County for at least 10 days?
Yes.
And you had also been a resident of the state of Michigan for at least 180 days. Is that correct?
This morning it was about 84.
I understand you were married on August 4th, 2007.
By the way, I have to come back here because once the judge starts talking.
Comfortable.
Oh, there he is. He's here.
Well, I said, how uncomfortable.
Yes.
I'm pretty sure he's going to get it.
Mr. Payne, can you hear me?
You hear me?
Can you hear me, sir?
I can hear you.
Two good-looking people.
I had you brought up again today. Again, you're not in any trouble, but I wanted you to be here for your landlord-tenant case. This is why.
Sorry, I had to go grab a Mountain Dew too.
Oh, you're fine.
Good looking dude.
Yeah. Who's hotter, Scott or the guy down below?
There, I think that's better.
Miss Payne reminds me of one of those girls from
Mr. John Barnes is here for
Teen Mom, who was dating her or is married to her stepbrother.
tenancy. She and the children were living there. And William
I don't
was
remember the
in jail.
name.
We had discussed perhaps the arrearage, and Keystone was gonna pay some, I'm not exactly clear what that status is, but it's not filed as a non-payment of rent, it's filed as a termination of tenancy. So, Mr. Barnes, what's the circumstance here?
We've been provided information, Your Honor, that shows that the tenant got some money under the SIRA program, and that last payment, and that caught them up and then paid some prospectively, December, January, February. And the last payment was on March 4. It was for March 4. And under the lease,
Yes,
that's weekly in advance. So that would have covered for the week up through March 11.
Oh, is this not one of those cases where they stole the money and didn't
We
pay
also
it?
were provided with something that says that when somebody,
Is it mother one thinks they're
SIRA
packing up and leaving this place? Look at all the stuff like
that the landlord agrees that they will not take steps to terminate a tenancy anytime before 1 month after the period for which the SIRA payment covered.
or that you get caught up basically.
So
You got like a month
it
buffer.
looks to me like, based on the payments from the SIRA program through Keystone, that as of this point today, technically the tenant is not paid as far as the rent goes. And as far as the tenancy goes, it's terminated. But under this condition of the SIRA program, it looks like the landlord has to wait until 1 month after March 11 to evict. At least that's based on my understanding of the information provided. You have any information on that, Caitlin?
I do. So in that article right above it, point C, it says that unless there is a violation of the lease or
Speaking of Caitlin, that's who I was thinking of about Teen Mom. That's the one, Caitlin and Caitlin Lowell. I
notice to
think.
quit for violating her lease, clause 24 for
Tyler.
getting a dog.
That's the kid's name, Tyler. Kate and Tyler.
And she was informed that she had a week to get rid of the dog, and she did not.
Raw.
Dog. No. Oh, you hear in the background.
It says the landlord will waive any other present and known grounds for eviction against.
There's no dog here.
Other than a payment of rent claim.
No dog.
Which was extinguished by the payment of rent. Or a claim based on a serious and continuing violation of the lease or law. But then,
Several problems here. I think this matter is going to have to be dismissed and started over again.
Oh.
It is filed as a termination of tenancy case. You've accepted payment of rent.
We hear this over and
Yes.
over.
If you accept payment of rent,
It doesn't even have to be the entire payment, just any partial
Yeah.
payment.
Termination of tenancy case. So that's problem number one. So the landlord has treated this half as a termination of tenancy and half as a demand for non-payment of rent. Keystone has treated it as a demand for non-payment of rent and paid the rent. And the SIRA program, which is the emergency funding during COVID, wasn't intention to just have landlords get their rent and then immediately evict the defendant immediately thereafter. So there's a moratorium. Once they accept it, essentially they have to start over again. So their rent is current through now. And if it was a non-payment of rent case, it would be dismissed. If it's termination of tenancy case, the landlord accepted rent in violation of the case that says you can't do that, pending the case in a termination of tenancy case. So I'm going to dismiss this case.
Had one job.
landlord is going to pursue a termination based on a dog or other violations of the lease, they can do that. But it'll be much cleaner if you start over again. And you can't have it both ways. You can't have a termination of tenancy and collect the rent from Keystone.
Scott.
Oh, I'm sorry. I don't
is the
mean to interrupt,
landlord.
But the payment from Keystone was received right before she got the dog.
Yes, the dog came at Christmas. It came from Santa. And the only reason I knew about it,
What do you think? He dropped it off.
we were late in rent.
It was there Christmas Day.
Yeah,
I didn't
she
even
had
know
nothing
it
to
was
do with it.
like
Santa threw
lease
it down the
violation
chimney.
until you were at my door. And then the next thing I knew, there was nothing but paper trail.
Mom, can the dog come back in?
You could not have the dog.
You can't talk to her
And I gave
directly.
you
You
time
guys can't.
to get rid of it. And
Judge?
typically when you live in an apartment,
Judge?
you usually don't have pets or need approval before you get a pet.
All right, well, let's back this up.
Back that thing up.
We talked about this before. Your kid's got a dog and you're not willing to get rid of it, which means you're subject to being evicted, kicked out of your house with your possessions put out on the street.
Yep,
So
I
if
found
a
that
dog's
out.
worth that much to you, then that may be all right. So let's back up. The
Damn it,
rent
Santa.
was paid. Well, the notice to quit was filed on January 18th for violation of the dog clause of the lease. When was the funding received from Keystone?
It
I
was
Just a minute.
The letter the day before the notice to quit of approval. Aiden, go get that manila envelope off my bed.
Just a minute, just a minute. I'm asking Miss Thornton.
We received it on the 23rd of December.
Yes, please.
Calling her a liar.
All right.
Do you think she said Santa because the kid was standing there?
Yeah.
You received payment from
Can
Keystone.
we talk to the dog?
Please.
Correct.
Husband's like, I'm happy I'm in jail right now, so I don't have to deal with this.
That does not violate the Park Forest case. The rent was paid before the notice to quit was served on the defendant. So that's dog, which is clearly in violation of the lease, and apparently the dog is more important than her tenancy. So,
I didn't know that it was until after the dog was already here.
all right, well, the dog's here now.
Yep.
And they served notice to you in January the 18th that I want you to move.
Evict the dog.
You didn't move. So we had a hearing on March 4th. I was supposed to adjourn at 7 days. I adjourned at 10. So the fact that Keystone has paid your rent prohibits them from pursuing an eviction for 30 days after December 23rd.
He looks content, doesn't he, Nancy?
On March 14th.
Yeah, he's like, no biggie.
Hey, Richard.
So it does appear that you're subject to a termination of tenancy.
Okay.
Yeah, the kid's standing right next. That's why she said that about Santa. You're right. No, that's kind of
Even though I got approval to have a dog this summer when I was working with Scott.
Yeah, I
mentioned to him about my son having a dog because he has no friends in town and he just moved there. And Scott
Loner.
have a problem with me having a dog for my son.
did we see these guys already, or is this one I watched on the couch?
You probably watched it on the couch because he said they heard this back on the 4th.
Yeah.
It's a pit bull.
I knew it.
Of course. He claimed that he was working, just like he just said. And Scott was like, sure, no, man, no problem.
The dog came for
Pit
Aiden.
bull.
'Cause Aiden's 12. He'll be 13 this month. I had to start working, so he was left here alone. So for one, it came from Santa as his Christmas, and then it was supposed to give him responsibility and also protection. I didn't think to ask Caitlin or any about the dog.
I didn't
until
think
she was
about
at my
it.
door, very upset when she saw me taking it outside to go to the bathroom.
Start smoking too in the house. Not even ask.
Apartment 4 at 126 North Main. If I was another tenant in that building,
A big
they
dog.
gave you a choice in January to either be subject to being evicted or get rid of the dog, and you didn't. You have 10 days to move out, or you're subject to being evicted. I'm really sorry it went down this way, but there appears they're entitled to the relief they're asking for.
It went from a dismissal
You have a
to
right to appeal this. You may contact.
So here's the thing too.
I have.
Why did? Okay, most places and I know this from renting out places for my in-laws. If you want to have a dog, there's either a pet deposit that you have to put down, or B, you can only have certain kinds of dogs based on the weight of the dog.
Right.
Okay. If you're going to buy a dog, why would you buy a pit bull of all things? That one
Right.
is going to make everybody in the apartment like, ooh, it's a pit bull.
Yep.
It's got a stigma on it. So people are going to complain.
Sure.
It's a big dog. It's going to tear shit up. It's going to leave massive dumps outside the apartment.
Yeah.
I mean,
So
why not have gone the other route and got something small
Yeah,
in the door?
ankle biter. Like if I knew that I wasn't allowed to have a dog in here, I like a small, yeah, I got you. And you're absolutely right. Santa is a dick.
Santa was not thinking.
I've contacted them and they messaged me, but they didn't get back with me in time for this court hearing.
Any chance this wasn't a full-grown pit bull?
I'm sure it is.
I submitted a draft judgment, Your Honor.
Not even a puppy.
It'd be funny if the dog just went flying up, jumping up over her right now.
The dog's tearing up shit behind her.
Has a right to possession. The lease clearly states you're not to have a dog. This is an apartment building with very little lawn. None, unless we're talking about the back parking lot. I don't even know where the nearest lawn is.
Dog just craps all over the parking
They
lot.
told you by notice to quit on January the 18th, they were going to move to evict you unless you got rid of the dog. So we went all the way to March.
They've had lots of chances, Benton, I'm telling you.
First, because I had to ask her for the
I
copy
don't
of
feel
the
bad.
lease. She just said violation of the lease, and there was no communication.
It says violation of clause 24 of the lease.
Right. Yep. And I didn't know.
Anyway, then we discussed it on March 4th.
And big
and
dogs.
10 days later. So unless there's a stay or other action filed by legal aid, you have until
Her son is 13.
March
Not
20th
the dog.
to move, or you're subject to being evicted.
That's terrible, Amy.
I mean, the first thing you do when they say, "Hey, you're going to
Thank
get
you, Your
evicted,"
Honor.
you think, "So sorry. Let me take this dog."
And it's emotional support also.
Of course it is.
You couldn't have an emotional support lion in there. You may have some defense of emotional support. Many properties do not allow pit bulls.
Emotional support
So-
pit bull. I got bit by one of those one time,
we
by the
first
way.
moved in, there was
You don't
already
just get a dog
You were
and say it's
jogging.
emotional support.
Well, I was jogging.
You need a medical diagnosis and that sort of thing. There's more to it than just saying, "Hey, my son needs a dog for emotional support."
Yeah.
They don't want a pit bull in their apartment building, and I would. bet
I
the other
understand that.
tenants
I'm
in
not
there
trying to
don't
fight
want
that
either.
or trying to stay either. I just didn't understand the communication.
All right, well.
Yeah, communication is they want you out.
That's the harsh. Now we'll see if legal aid does anything, but.
They've went all the way to the end of this. That's the thing, and they're still there.
Mm-hmm.
All
You said
right.
Knowing
March 4th?
right away.
That would be the 24th of March.
Okay.
All right, thank you.
Thank you, Your Honor.
Thank you.
What do you got lined up? Anything over there? Or?
Well, it's something to do with
The motion
divorces.
is to amend or modify the judgment of divorce.
The husband already bailed, by the way. He
He's
was here a second
disconnected.
ago.
I've waited at least 10 minutes since he's
Another
disconnected.
pain.
He still has.
Oh, real quick. He's locked in. Can't get out. He's trying the door.
You mean tell me there's a bunch of locked doors at prison? Come on, man. A little freedom. Yeah, this lady's husband was here and he bailed. He was like, he bonked out. And they were holding up a sign like this that said, "Turn on your audio." There he is. He's back.
He's driving a
Mr. Whitney,
truck.
are you able to see and hear me? Mr. Whitney.
Mr. Whitney needs one of these.
Tim? Bottom left.
From one pain to another. There's the turn
Yeah,
on
oh, I
your
love it.
audio, you dumb effer.
I like how high they have to hold that sign, by the way.
Yeah, it's
Still
like
there?
Yes, he's trying to connect again.
they're
So
stepping
is this
on
a
step.
divorce proceeding?
It's something to do with divorce because the last couple that was here that I came over to, they were divorced as well. So
I hear you.
All right, we can't see you, but we'll go with this. Mr. Whitney, you have, there we go. Mr. Whitney, we have a motion that's entitled Motion to Amend or Modify the Judgment of Divorce. Ms. Payne, have you received a copy of this motion?
Yes.
Miss Payne in the back of a police
Ms.
car.
Payne,
right
do you
now.
have any objection to the motion?
No.
Mr. Whitney, if you could please explain the motion, because I've read it a handful of times and I'm a little bit confused.
Uh-oh.
Basically, we sold the house and the people do not want the property next door. So I am taking responsibility of it and taking over payment.
Huh?
And are you
Pause.
going to
Let's talk to
hold Ms.
Proudbird for a
Whitney-
minute, who wants to be an idiot, I think. Unless I read that wrong. Why is Creedence's microphone so much louder in both court and in chase videos? It depends on what you listen on, by the way. Every single thing is going to sound differently. Do you guys normally, is that a thing? I don't know. When I listen back, I don't notice it.
He has a commanding, booming voice.
And by the way, if you don't want us talking during any of this, you can go and watch these yourself, just like a chase by yourself. Then you don't hear anything from the peanut gallery. Do you not understand that? I mean, this is what we do, Proudbird.
You can't have Ben and Jerry's ice cream without Ben and Jerry.
Just go watch
Otherwise,
it.
it's just great value.
What? I don't understand why you people don't get that. Like, that's very weird to me. Very weird that you guys don't understand that. And there's thankfully, there's only one in every 500-600 people. Thank God that understand that we're doing something different. This is a show. We're all hanging out. We talk back and forth in the comments. Go watch it yourself. Then you can listen to all of it yourself. We don't own any of the stuff that we're watching. You go and watch that yourself by yourself. Then you don't have any talking.
More importantly, Proudbird, what do you think of me? Go ahead. Say something nice.
I just don't get why people don't understand that. Angie, glad that you're
Angie, doing well.
Stuff went
Good.
well in your home. I saw your message. Very good. Happy to hear that.
That's good stuff.
And yeah, exactly. I just go on and watch it yourself. There's if you don't understand what's going on here, then there's no need to be here. It's very, very simple.
Once again, the communication process is broken down.
We're getting a divorce, and we're going to be in front of Wexford Circuit courtroom soon, Proudbird.
Boy, that escalated quickly.
Next.
Heading on.
Ms. Payne harmless and have no obligation to pay any, is there any, sorry, hold on. Is there any debt related to that parcel?
Yes, there is.
And are you gonna hold Ms. Payne harmless from any debt?
No,
So you're going to have her pay half of the debt?
no, I'm not having her pay any of the debt. I'm just taking it over.
Well, that's what hold harmless.
It's just,
Okay.
there's a
You
quick deed
misunderstood.
signed already. I am just taking over the debt and proceeding with the property and see what I can do with it. See if I can get it sold or whatever needs to be done.
Hey, Sharon.
Did you already
Rick.
close on the sale of the home?
No, that's later today.
Okay. Ms. Payne, you understand that apparently, and this was not well described in your divorce judgment at all. Whoever
That is
drafted it did not draft it very well, but it looks like the marital home included a parcel with the house on it, and then next door was another adjacent lot. Am I correct, Ms. Payne?
That is correct.
And now I'm a little concerned here that on the defendant's motion to amend or modify the judgment, it says that 2 mortgages will be paid in full prior to any division of net proceeds. However, the divorce judgment says 2 mortgages shall be paid. That's consistent.
Oh, another one paid by Mikey. I
The
got it.
balance
All right,
of
never
the
mind.
Forefront Credit Union debt on a 2012 Toyota Camry shall be paid. The water softener debt to Aqua Finance shall be paid.
Oh, no.
All closing costs, including broker fees, shall be paid.
They
And
got
then the parties shall
bamboozled into
divide
a
the net
water softener.
proceeds. So in other words, the divorce judgment actually includes more things to be paid from the proceeds of the sale.
Correct.
So, Mr. Whitney, do you agree that those additional proceeds will pay those debts before there's an equal division of the value of the asset?
Hi, Joseph.
Correct.
Am I getting the feeling that Molly is just a bitch?
The only thing we're looking at is separating the two pieces and the debt that is owed on that property that I would take over because we do not have enough money for what they offer to pay that debt.
Hey, Kristen.
So let me get it straight.
This pain.
My dude right here is going to pay the difference of the debt on their property they're selling today. That's going to take a loss. He's going to pay that. They had a second property that was attached to that property that they don't want. So now he's willing to take over and pay that while she continues to sit in the back seat of this car looking pissed off as all outdoors.
I love the water softener thing. That's my favorite.
Oh, the water softener is such a scam. And that's very, very expensive. Very expensive. You're talking over $10,000.
Do you have any objection to what Mr. Whitney's asking for?
No.
All right.
No.
So I can grant an amendment to the divorce judgment that the parcel that contains
exactly
the
right.
home will be sold.
Bailiff.
When the property is sold, the 2 mortgages to Quicken Loans and Forest Area Credit Union shall be paid. The balance of the Forefront Credit Union debt on a 2012 Toyota Camry shall be paid. The water softener debt to Aqua Finance shall also be paid. All closing costs, including broker fees, shall be paid.
Hey,
Then the party shall divide any net proceeds equally. Do you agree, Mr. Whitney?
No, I do not. The loan with Forefront Credit Union is the property that is not going to be sold that I'm taking on.
Okay, hold on.
And that address is 4858.
Take it that's where he's living
All
now.
right. So let me rephrase
Maybe.
that. Parties will sell the parcel with the marital home. The sale proceeds will go to pay the Quicken Loans mortgage. It will then pay the Forefront Credit Union debt on the 2012 Toyota Camry, the water softener
Camry,
to
baby.
Aqua Finance, all closing
2012.
costs, including broker fees, before the division of any proceeds. Is that correct, Mr. Whitney?
By the way, this
Yes,
isn't
it
a
is.
pajamas. This is
that
an
correct,
actual
Mrs.
shirt.
Yes.
Why?
The
The
second
confusion.
step is the remaining attached parcel with that address stated by Mr. Whitney will be awarded to Mr. Whitney, and Mr.
wear it
Whitney will be
one night,
responsible
and
for
then
any debt.
everybody
Is that correct?
Yes.
That's right. You were for the
Ms. Kane,
late.
do you agree?
You're really late when I had to
Yes.
throw a shirt on real quick.
All right.
Come on here.
Now comes the magical part. Who's going to draft this order?
I know
I
the
don't-
realtor Angela Tuck said she could either stop in and get it, or if you wanted to email it, she can get it via email.
All right.
Why
So
can't they-
they're basically figuring out what they're all going to take care of before they split everything up is what I'm
So
gathering.
they're selling the marital home today. It's closing today.
Mm.
Once it's closed, the proceeds from that have to go and pay off all those things listed except for the additional parcel of land. Yeah, I don't wear pajamas. I don't even own any. The parcel of land that he is now is full of holes and stuff. You see right through me. That he is now taking over.
Got it.
I'm wondering what's going to be left, though. That's a
by
lot of
the
stuff
looks
got to
of
be
her
paid off.
By the looks of her face,
She's walking away with like next to
Debt.
nothing.
Debt, I think.
Well, he's taking on everything. It's supposed to, all the debt's supposed to be paid off with this proceeds. So, what do you think? She cheated on him. I mean, they both. She kind of looks like him with long red hair. Put long red hair on him. That's kind of her.
You never know.
Relatives. Make sure you like this video, by the way, and share it if you're ever on Facebook. Thank you.
It's okay. I understand the misunderstanding. Who was drafting the order? The court doesn't draft the orders. The parties draft the orders.
They don't know what that means, Your Honor.
I'm going to assume nobody's drafted an order to this point. Am I correct, Mr. Whitney?
Yes, all there was is on the property, there was something drafted, which I give the copy, and all it was is a quick deed for the property stating that she signed it over to me.
Hey,
Okay.
Again.
I understand some confusion here, and that's okay because you guys are doing this without attorneys. I have now granted your request. I have now verbally stated the order. Now the question becomes who drafts the order? Which one of the two of you is going to draft the order? I'm going to assume neither one of you know what you're talking about as far as drafting.
It's on Mikey internet.
That's okay.
Sorry,
No.
Apologize. You're both
Let's go
illiterate
ahead
as
and
hell.
draft an order and have it prepared.
Oh, I'm sorry, Joseph.
The point here, however, is each party has the right to object to that order if they choose to do so. But if I draft an order that says, as I described, Mr. Whitney, do you agree?
Yes.
Ms. Payne, again, do you agree as I described it?
Yes.
All right, good enough, folks. I'll go work on that order. Anything further, Mr. Whitney?
Has anybody been drafted? No,
I'm
sir. I've never
drafting the order.
served in
When
the
would be a
military.
proper time to pick it up or have the agent pick it up?
I don't know. I've got other matters to take care of first, and I have to be in Lake City in 45 minutes. So the answer is
not today.
I don't know. Could be 4 o'clock. Could be tomorrow. I've got other matters. So
The only reason why I'm asking is, are we supposed to sign on that thing for today? And they needed that to get it to go through. So.
okay. Ms. Payne, are you able to come to the courthouse today?
Like the one near the airport.
I'm in
Jay?
Grand Rapids right now. I'm sorry.
That's okay. Looks like you're being chauffeured.
Your Honor.
In a chauffeur.
All right, I will have it. I will do my best to draft it in the next 15 minutes. Do I have anything else left here?
No, not up here.
All right, I should have it
Well,
drafted in about 15 minutes.
He's going to go do the drafting, and we'll hunt over to JG Davis with some magistrate stuff. Let's see if
he is born
what's
and raised in
happening.
Georgia. He's never lived anywhere else. He lives.
Oh,
with his
here we go.
family.
Gonna tell us how
Two,
great this person is.
Siblings who are 16 and 19,
Yeah.
and he also has a young child. He
Child.
has lived in the Stone Mountain area his whole life. So right here in DeKalb County, and he was working, doing stocking for Amazon at the time of this arrest. So we understand that this allegations.
Rob, look this guy up.
With his lack of criminal history and his ties to the community, we are asking the court to consider a $5,000 bond.
I have one question. He has another case with an A on the end, and I think it's related to this case.
Is it on this? It's not on this calendar, but it's.
No, I
it's
just
related?
saw, yes.
What's that case number?
It's 22-020073.
They have a lot of customers through courtroom. You ain't
All right,
kidding.
bear with me.
I know. I wish we
Your
had a
Honor,
clear
I'm
shot of
sorry,
their
I kind of
face.
like came in just towards the beginning of this. Is this position 16?
Yes.
Yes.
So I had been looking at that case last night. I'm sorry, and it looks like counts 3, 4, and 5 from the calendar were dropped.
Hi, Val.
Count 2 didn't have a listed case number, but there had been an additional.
Welcome to the peanut
count,
gallery.
For battery, it looks like maybe the aggravated battery had gotten dropped in lieu of a battery charge because it's under the same case number as she was saying.
I see. So they didn't dismiss the original.
I
see.
Yeah, so it looks like they dropped 3 of them and then added 1 back in.
Well, hold on. There were 4 charges originally on the case number.
Jay, we're in Georgia,
It just
I
had
believe.
battery.
I
And then the
think.
person who's
Yeah, it said Stone Mountains. I'm guessing Georgia. Yeah.
original charges or warrants rather.
Also,
So I
that's
just
where
want
Jake the Snake is
clarification.
from. Stone Mountain,
You
Georgia.
understand,
Weighing in at
enforcement of the
200
state is
pounds.
Pursuing under the A case, and as a result, there's only 1 warrant or charge. Or are they pursuing under the case without the A, or in addition to the A, and there is now 5 charges?
Damn.
And Judge, just to be completely candid with the case, I'm unaware of any of that. I just have what is on the calendar today and the warrants that are on the calendar. So I'm not familiar with that A case. I don't have any additional information.
Well, that's going to be huge because generally my experience,
Huge deal, bro.
either adding a charge or we're addressing the correction of some charges that were then either dropped or what have you, or there's an incorrect issue.
And if you'll
Mike,
give, I'm sorry. I'm happy to investigate and see
Please.
if I can get additional information.
That's fine. Well,
Judge got a hair in his mouth.
I understand you may have to make a call or I guess to send an email. Do you have to make a call or send an email?
Judge, I can stay on here and make a phone call from my desk. So
Let's do this.
Wow, multitasking.
We're just gonna have you sit back down. It might be to your benefit. We don't know yet. We're gonna investigate. All right. So we'll take a seat and come back to you.
This is the most upbeat
Boy.
judge I've seen in a while.
No,
Yeah.
we have 1 charge.
She is
5.
all business.
Let's figure that out. All right.
I like this guy.
Attorney Fee,
I do
I
too.
understand this is still your client, so I'm not going to let you go. But do you have any others before I get to attorney?
Thank you,
Sure,
who's
I
handsome.
have both positions, 18 and 19, and I believe
Look at her.
19
She ain't kidding.
is
She's on the phone at her
100%.
desk and still on here on Zoom.
Oh, hold on.
Yeah, I believe both
Yeah,
of
phone
those are
call.
language lines as well.
Yodel.
So I guess you'll just
Mm-hmm.
we'll talk to you again at the
Peanut Gallery. Gotcha. Mm-hmm.
Okay?
Mm-hmm. All right.
Been great working
Bye.
with you thus far. All right, Attorney Taylor, we can turn on that camera and we'll start working with your matters.
That sounds wonderful. I'm ready to go.
All right, let's come back
Judge
to Mr.
Urkel.
Smith. And so let's just go right back here to the
Let's do it. Let's hear about how great of a person this next one is.
Absolutely. Before they jump over there, by the way, I found another courtroom here
And with respect to bond,
in
Mr. Echo?
Monroe County.
Thank you, Your Honor.
What,
I'm requesting a PR bond for Miss Cheatham. I
this
do
in
understand
Rochester,
pretrial
New York?
services
Is that the New
requested a
York,
cash
state
surety
line?
bond, but I can only assume that's based on the fact that they had listed one of the possible charges
Doesn't
as
say.
a felony charge.
Yeah, it's Michigan.
Miss Cheatham has been a
Michigan.
lifelong Monroe County
Another
resident,
Michigan,
with
all
the
right.
exception of a couple years she lived in Lucas
Robert?
County, Ohio. She has a very limited criminal record. Her last conviction was 8 years ago for a driving related offense. I do not believe that she is a flight risk, nor is she a danger to the community. I would like to address the one instance of failure to appear that's listed on the bond report. I did discuss that with Miss Cheatham. She is fairly certain that that was from the case from 2002,
Dewey
just 20
Cheatham
years
and
ago
Howe.
when she was 18. And for lack of a better term, Your Honor, young and stupid and missed a court date. So we're requesting a PR bond with appropriate conditions.
Get right to it.
Young, dumb, and full of
Magistrate. Is that what this is?
Another
one of the
Has to be.
magistrate stuff.
This is a misdemeanor offense. There is no felony charged here. Based on that and a review of your record, we're going to go along with your attorney. We're going to set a $1,000 PR bond. And that means you're going to get out of jail today You need to follow these conditions, okay?
Okay.
Number one, you
Oh,
need to
that's
show
so
up on time for every future court appearance. You're not to violate the law while out on bond. You're not to leave the state of Michigan without permission of the court. Do you understand that?
Yes, sir.
You don't see any other need for any other conditions based on your record and the offense here. Well, the court's going to do this, ma'am. It's going to order that you not use, consume, possess alcohol or any other illegal controlled substance, all right?
No more drinking.
Yes, sir.
Any questions regarding bond?
No, sir.
Which is your favorite?
Ms. Rucka?
No, Your Honor, thank
Mine
you.
is
That concludes your
Roger
arraignment. Thank you, ma'am.
Thank you.
exactly, Glenn. Glad you got it. Oh,
Mr. Johnson, Your Honor.
Court will call the
All right,
case of
Johnson.
People State of Michigan versus Calvin Lee Johnson, file 220716 FY. Time and date set today for an arraignment. Counsel, your appearance for the record, please.
Leah Burka for Mr. Johnson. We'd waive formal reading of the complaint and stand mute.
Mr. Johnson, your full name, please.
Calvin Lee Johnson Jr.
Very good. In this matter, sir, you're charged with the following. You're charged with 3 crimes. In count 1, you're charged with assault with intent to do great bodily harm, less than murder or by strangulation. If you were convicted of that, maximum penalty is up to 10 years in prison. It'd be a felony conviction, maximum fine up to $5,000. In counts 2 and 3, you're charged with domestic violence.
Oh,
Each
Calvin.
of those counts are misdemeanors, maximum penalty up to 93 days in jail, maximum fine of up to $500. Sure, do you understand the nature of those 3 charges and the maximum possible penalty?
Yes, sir.
The court's going to enter a not guilty plea to all 3 of those charges for you. We're setting 2 new court dates. Your next court date, sir, will be what's called the probable cause conference, and that is on March
Calvin's a little too old to
23rd,
be doing that kind of
9
stuff.
o'clock in the morning before Judge Brown. That's a time when your attorney can talk to the prosecutor trying to resolve the case. If it cannot be resolved, you're entitled to a hearing. It's called the preliminary examination. That's set for March 29th at 1:30 in the afternoon before Judge Brown. Sir, for your next court date, are you going to hire your own attorney or request a court-appointed attorney?
Court.
Can I request a corner attorney?
Yes. Raise your right hand,
What?
please.
Attorney?
The other hand.
Oh, my bad.
You swear or affirm to tell the truth.
The
with
other
respect to
right
financial
hand?
Questions the court's about to ask.
Yes, sir.
You put your hand down. Thank you, sir. Sir, are you currently receiving any state or federal public assistance?
I get SSI disability.
Very good. Court presumes that you're qualified. Court's going to make that finding, grant you a court-appointed attorney, and that person will be in contact with you in the near future, sir, and appear with you at your next court date. With respect to a telephone number, sir, do you have a valid telephone number if you postpone they can reach you at?
He been
Yes, sir.
choking his old lady.
410-90-97.
Don't nobody call him. Blah, 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 blah.
They will put that on the court-appointed attorney form. Ms. Rucka, I see bond is currently set at $10,000 cash and surety bond. Any input with respect to bond?
Yes, Your Honor, we would request consideration for a lowering of Mr. Johnson's bond. He is a Monroe
Young and
County
dumb.
resident. While he does have some criminal history, none of it is violent or assaultive in nature. As he indicated, he is not currently employed, but he is receiving SSI benefits due to muscular dystrophy. So we would request consideration for a lower cash bond with any conditions the court deems appropriate.
Wow.
Right. The purpose of bond, Mr. Johnson, is not to punish you, but it is to ensure that you show up in court and also to protect the community.
He has muscular dystrophy, you asshole. I'm kidding, Cart.
The nature of the charge here is serious, sir. You're presumed innocent, but it's a 10-year felony assault with intent to do great bodily harm, less than murder. Court's going to keep bond as is set by the magistrate. We're going to add a condition, though. We're going to add condition H, which means if you post bond, court's going to add that a GPS monitoring device be attached. With that amendment, any questions on bond, Ms. Rucka?
No, Your Honor, thank you.
No contact provision still applies here. Any questions, Mr. Johnson, regarding bond?
So my bond is $10,000?
$10,000 of bondsman, I believe, would take 10% of that to post that for you. But that's your bond.
$10,000.
Reviewed at any court date.
Just less than murder, huh?
Choked it.
That's a-
Apparently, his muscular dystrophy does not affect his strength in his hands.
Right.
He was choking his domestic partner within an inch of her life.
I just laughed when I was out of the porch with the your other right, please.
Use your right hand. Oh, your other right hand. So
2,500. As far as the do not return.
this judge is knocking them out over here, by the way. He's just moving them in and out.
Yeah.
I don't really see that that's the primary issue here. So I'm not going to order a do not return, but I am going to order a $2,500 regular bond. Okay. And that'll be the order.
I can tell you right now that if I got hemmed up on something and had to go in front of him, I'd appreciate that a
We
lot
have
more than
next.
some of them.
What's the breakdown?
Did you notice, like
all
with
right.
this
So
other
the
judge a while ago here in
breakdown
Monroe
is-
County? Typically, they ask like, "Oh, I'll send you to a breakout room to see if you qualify, for a public defender." He just
Right.
said, "You got a job? No? Okay, you getting one.
500 for the
Done and done."
That's true. Real quick, because he said no, just SSI or whatever.
Yeah, just like that. Didn't even. Okay, we're gonna send you to a breakout room. Figure it out. Nope, done
All
right
right.
there. He's no nonsense.
By the way, this judge is at home.
Is your
course.
client here, Attorney Taylor?
He is very relaxed. Oh, you mean
Is that,
his
or is that
house?
along
Okay.
these lines?
Thought you were like,
So,
he's
Mark,
very at home in the courtroom.
He should be here. That is English speaking, so he should be ready to go.
Okay, that's right. I have a circle the spreadsheet. Give me 1 second to pull up the matter.
Do you think he's just super nice because he's new? Maybe.
He's not jaded and beaten down
Yet.
by the system yet.
Yet.
Not unlike our bald-headed. By the way, good for Judge Nicholas over here, who embraced his bald head. He didn't put on a toupee. No,
Good
sir.
point.
Bald and beautiful.
Well, he was banging right through him. That's why I jumped back over and then
All right, Mr. Colvin, you've got 4 charges. The first of which is possession of marijuana with the intent to distribute. That's warrant number 22-W-002935.
There you go. Something going on in there?
The second charge is operating a vehicle without insurance. That's warrant number 22-W-002936.
I think that's the most common thing to
Position,
get.
charge 3 is
Charge.
unregistered vehicle, no tag,
That too.
22-W-002937. And the fourth charge is
Drugs.
possession of open container of alcohol beverage. That's warrant number 22-W-0029.
For a drive on the weekend with an open container, no big deal.
No registration on the car, no
Maryland, you have 6 cycles,
insurance. Why
which
not?
includes a 2009 armed robbery and kidnapping.
No.
And handgun, use of handgun, use of a crime, as well as a 2012 possession of a telecommunication device, I guess, or I believe was in a penal institution. Okay.
What? A penis? What?
I'll go ahead and hear from the state.
Unbelievable.
Judge, the state is recommending an $8,000 bond in this situation, mostly based on the amounts that were found on the defendant. He does not have criminal history out of Georgia, just what you mentioned out of Baltimore. And dollar recommendation is what the state is.
I'll probably jump right into it. I wouldn't doubt it loud. Who knows?
What was your recommendation?
You could be elected sheriff and never know anything about the law.
It's true.
That's an $8,000 regular bond, Judge.
All right, let me hear from the defense.
Your Honor, I believe it may, I'm not sure. There were a lot of emails going back and forth and some technical difficulties trying to prepare, I know. But this
What good you
was
got to say?
actually, we were able to consent to the $8,000 bond. But I can go ahead and just talk a little bit about Mr. Colvin. He does have that criminal history out of Baltimore, which I understand.
But
is
who doesn't? I
concern
mean,
when it
come on,
comes
it's Baltimore.
to, leaving the jurisdiction. But in this case, he actually is in the process of trying to move down here. So around the time of this incident, he's actually house shopping. He has 2 children, and
Thank you,
he's
Robert.
in the process of bringing them down. So he now owns his own business. He does like it's
Car
called
washing?
home improvement. So he does everything for it. He does the carpentry, he does
Believe
the
so,
plumbing, the
Hose.
electric, the masonry, like you name it, he's doing it.
Creed, would you like to
And
see
he
the
is trying
saddest woman
to
on the planet?
basically
Just
set
real
up
quick.
a here, and
There
he's
she is right
going-
there. Saddest woman on the
Oh, sorry.
planet.
If that tether cannot be attached today,
Oh, she's got a tether.
She's crestfallen.
He also does, just to mention quickly, he does have a hematoma in his head. I don't think it's presented any issues, but it does need monitoring by doctors. So that is just a smaller concern in making sure that he has a reasonable bond today, so that he can be released.
Okay.
Okay, you're saying you're living in that. Okay, hold on for once. Hold on. We don't want to have you say too much here. Hold on.
Shut your mouth and know your role.
Shut up!
Thank you, Creed.
And your consent was a $8,000 bond. Is that correct?
That's correct.
His bond is less than the guy that was choking the domestic person over here. And he's got the hematoma in his head. Hematoma.
Thank you for the fake dono, Mayor.
I'm a tumor. Nah, I'm a tumor.
T. Ms. Rook is
No.
appearing on behalf of the defendant.
dude.
For your full
Murder,
name, please,
maybe?
for the record.
Dustin Michael Masick.
Very good. In this case, sir, you're charged with the following. You're charged with 2 counts. In count 1, you're charged with fleeing or eluding a police officer in the 4th degree. If you're convicted of that, sir, maximum penalty is up to 2 years in prison, maximum fine up to $500, and the Secretary of State would impose license sanctions and suspend your license for 1 year.
He was in a
Count 2,
chase.
you're charged with resisting or obstructing a police officer. You're convicted of that, sir, that'd be a felony offense. Maximum penalty is up to 2 years in prison, maximum fine of up to $2,000.
He looks confused.
Also, a consecutive sentence could be imposed if this offense arose out of the same transaction as you're fleeing and eluding. Sir, do you understand the
Sure.
nature of those charges and the maximum possible penalty?
I do, Your Honor.
Court will enter a not guilty plea, sir, for you. We'll set the matter for 2 new court dates. Your next court date will be what's called a probable cause conference. That's set for March 24th in the morning. That's the time when your attorney can talk to the prosecutor and try and resolve the matter. If it cannot be resolved, then you're entitled to a hearing. That hearing is called a preliminary examination. That's set for March 29th.
Down there with
1:30 in the
Leah.
afternoon. Both
Is that a painting on the wall that Mad Cave made of her right above her?
I saw that
ponytail?
too, and I was wondering, is that like a self-portrait? Because it could be her.
I think it is her.
I mean, she is, very sexy when it comes to painting herself.
of those are before this court. Sir, will you be able to hire your own attorney, or are you requesting a court-appointed attorney to represent you?
I'm not sure yet. I'm have to look at my finances. Do I need to request a court-appointed attorney now? Or can I have?
Let's do this. If you're not sure if you have the funds, sir. at this
I'm not
time,
sure if I qualify, Your Honor.
Can you raise your right hand, please?
Yes.
You swear or affirm to tell the truth with respect to the financial questions the court's about to ask.
Yes.
You put your hand down. Thank you, sir. Sure. As far as income, how much money do
Surely
you bring
he's
home
got
and take home pay per
$40
month
in his bank
approximately?
account, right?
Probably about, my hand's been slow, about 2,500.
Very good. Do you have any money currently saved up in a checking or savings account or anywhere else?
I do, but I have 2 cars impounded that I have to get out, so I'm not really sure if that money's gonna exist very soon.
Okay. Do you have any property, sir, other than the cars that you could sell?
He's
to
driving
use to
2
retain an
cars
attorney?
at the time.
I do.
What type of property, sir?
I mean, personal items.
Section 8 home.
I mean, do you have gold, jewelry?
No,
something you built in the next 5 days?
Crypto.
No,
Flat
no, I don't have
screens.
any property or anything like that.
Then you
Court's gonna
don't
find
own
at
it.
this point in time that you are qualified for a court-appointed attorney. Court's gonna grant your request. An attorney will be in contact in the near future, appear with you at your next court date. Ms. Rucka, bond argument, please.
Thank you, Your Honor. Pretrial Services is recommending a PR bond for Mr. Masick with conditions. We are requesting the court follow that recommendation. My client's a Ohio resident. He has lived in Lucas County for many years. He is gainfully employed, as he indicated. He has only one prior conviction on his record more than 10 years ago. So we would request a PR bond.
Okay, very good. Court's gonna go along with that request. We're gonna set bond in this matter at a $1,000 PR bond. Sir, it does look like you are employed. You have no known failing to appears. You have a minimal criminal history. You have no current substance abuse issue according to self-reporting. This incident is serious, however. We're going to require that you report to pretrial services upon your release from jail, sir. They'll monitor your bond conditions, and they're as follows. You're ordered to appear for all future court appearances on time. You're ordered not to leave the state of Michigan or the state of Ohio without permission of the court. You're not to commit any crime while on bond. You're to notify the court immediately in writing of any change of address or telephone.
You can't leave the state of Michigan without permission, or the state of Ohio. So you got to have permission to leave Michigan to go to Ohio, and from Ohio back to Michigan, or
so.
$1,000, by the way, $1,000 bond.
Number. You're to make all reports.
bless
starting with that
you,
report to
Lee.
pretrial services. You're not to use, possess, consume alcohol or any other illegal controlled substance. You're not to possess or purchase a firearm or any other dangerous weapon. Those are your bond conditions, sir. Do you understand those?
Yes.
I'm getting $9,000
That
back in
concludes your
tax
arraignment for
returns,
this
Your Honor.
afternoon. Thank you, sir.
I'm going to take you over to the 13th Judicial District in Kansas.
More arraignments here, then we'll go
Judge
back to the
Sanders.
landlord-tenant
That's,
docket for those that are waiting.
kind of interesting over here. Let's see what's going on.
Oh,
But Your Honor,
F this
that pay was
judge
solely
and his
earmarked
books.
for her rental expense to be prepaid for 6 months. That ought to be off the worksheet for 6 months because she does not have to pay that expense if she would have kept true to her word. Your Honor. There was no denial or dispute that her expenses, Mrs. Worth's expenses, incorporate her children from a prior relationship. That's not fair to Mr. Worth. That's not fair
No, the
just
divorce.
equitable. That's why her food and restaurant costs per month is close to $1,500, Your Honor, just under.
Well,
That's why all these other expenses are what we need
somebody's eating good.
because they incorporate 2 more kids that Mr. Worth has no legal responsibility to support. Your Honor, need versus ability to pay, Mr. Trey argued it, but then he said, no, we want 20% of the difference for spousal support, which has absolutely nothing to do with need versus ability to pay. So Mr. Turley's own argument contradicted itself. First, you say need versus ability to pay. Then he says, no, it's a percentage. No, Your Honor, it's need versus ability to pay. Mr. Worth does not have the ability to pay. There's been comment and criticism about
Steve
this
Turkey
house.
and
Well, Your Honor,
Mr.
it
Pringles.
makes sense to have one or the other party in the house rather than
Judge
having both
Sanders
rent
Ford.
and have a mortgage payment. Mr. Worth has the ability to take care of the house. Mrs. Worth did not want that responsibility. He's in the house. He'll make the payment until such time as they either refinance it or sell it. And Your Honor, those 2 options are on the table.
How much is Mrs. Worth worth?
Either one now. He just started a new job. a week ago.
$1,500 a month
Your
for
Honor.
food. Is,
So he has
somebody's
some
got some
irons in
money.
the fire now that if he doesn't do what he needs to do at his new job, if he's distracted, we won't have to worry about any quarterly bonus because he won't be employed. Mrs. Worth doesn't have that burden because she's now a full-time student rather than working as she did last year.
She's a student now, JG.
So when you look at the affidavit and the legitimate,
She's going to school to be a paralegal for
Mr. Worth does
Steve
not have
Turkey.
the ability to pay spousal support. He does propose he pay that home pilot payment. It's high.
Is he
Parties knew
vaping?
it was high when they went into it. When the company went into it, it's a
Judge is
60-month
vaping.
lease. Nothing unusual about that. What is unusual is they didn't make a down payment. So it's 60 months on everything. And the Honda Pilot that she's driving is 8 years newer than Mr. Worth's vehicle, give or take. And it was about a $40,000 to $50,000 automobile.
You're driving a Honda Pilot, you're eating $1,500 a month?
So, Your Honor,
It didn't put out worth hell.
guidelines, that's the bonus. There could be a $10,000 bonus. The guidelines do not provide for this percentage payment. They're guidelines. So Mr. Turley is asking for something that's not provided for in the guidelines.
Judge is sitting on that book.
Of course, familiar with child support. What we are proposing as a convenience, so the parties don't have to march up and down, back and forth to court, is simply do 10% of the net to be done with it, rather than making a recalculation of child support whenever Mr. Worth may receive a bonus. So, Your Honor, our position still
She wants
stays the
10%
same.
of his
The
bonus.
ability to pay, the domestic relations affidavits of the parties do not provide that Mr. Worth has the ability to pay the spouse's support, especially in the amounts that Mrs. Worth is claiming, over $2,000 per month if you include any potential bonus. So, Your Honor, may it please the court, we request that the child support be as provided in the child support worksheet we attached to the exhibit, 10% of any net bonus for additional child support, just for the convenience of the parties in the court. That no spousal support be ordered, except for that $905, $900 give or take, Honda Pilot payment, Your Honor. That's the
How much?
request that we-
$905
For a Honda Pilot?
Well, and remember what the court does here, just a temporary order anyway. We're not.
I thought it was bad that she was eating $50 a day.
Establishment.
But
maintenance or anything like that, but just for the time being. So, after listening to the
God
statements to counsel, the court finds that that it will
expensive.
adopt the parenting plan and the other proposed agreements here that have been mentioned. Also will adopt Mr. Worth's worksheet, child support worksheet. I will set the child support, and I believe it is in the amount of $1,377 plus 10% on this maintenance. No,
look at that face. She is just like
it
cursing.
was that 10% figure of the bonuses.
I bet he's going in saying no more bonuses, no more jelly of the month clubs, no more.
Okay, and as far as maintenance is concerned, the court will order that the petitioner pay the payment on the vehicle, a $900 per month on the Pilot, plus $750 in addition to that.
Is he paying for her Pilot, I take it?
Yeah.
Plus 10% of that gross that you guys were talking about. So that'll be the order of the court.
And payments are gross.
Your Honor, on the child support 10% bonus, is that gross or net?
I'm sorry. Gross.
10% of the gross.
Okay. So, counsel, that will be the order of the court.
Boy, things are different when you come to a court with some higher paid lawyers now. I mean, it is like night and day with things.
Oh yeah, you get what you pay for with an attorney, like the free ones that most of these people get. Come on, man.
I think, Your Honor, I think that covers all the outstanding issues.
Okay.
Judge,
right.
we agreed to adopt some of my language in my motion, so I think it'll be easiest if I prepare the order, which I will do unless Mr. Thompson wants to.
I
Okay.
agree, Your Honor. I agree.
All right. Yeah, and you can just put that through eFlex and it'll pop up for me.
That's crazy
And,
money.
So I can sign off on it. Okay.
Thank you,
Thank
Judge.
you, everybody.
Wow, that was
Thank
an
you, Judge.
interesting little bit to
Mr. St.
grab
Bernard,
there.
Your Honor.
Mr. St. Bernard is here.
Versus Richard Andrew St. Bernard, file 2207.
St. Bernard, Creed.
time and date set for an arraignment. Mr. St. Bernard, your full name, please, for the record.
Richard Andrew St. Bernard II.
Sir, Ms. Rucka, your appearance, please.
Yeah, we're on behalf of Mr. St. Bernard, we waive formal reading of the complaint and stand mute.
Very good, sir. In this case, you're charged with the following. You're charged with possession of cocaine less than 25 grams, second offense. That means
Dog
if you're
likes the
convicted of
white
this
stuff,
offense,
baby.
sir, be a felony conviction on your record, maximum penalty would be up to
Just like
8
any good
years in
St.
prison, a
Bernard,
fine of up to
he finds what he needs to in
$50,000.
the snow.
So you understand the nature of the charge and the maximum possible penalty.
Yes.
Is he still high as hell right now?
Yes, sir. Was that yes?
Yes, sir.
Very good.
He looks more of a crackhead.
We're just going to set 2 new dates in this matter.
Yeah,
That
the
for you
crack.
will enter a not guilty plea to that charge. Your next court date will be March 24th at 10:30 in the morning before this court. That's a time when your attorney can talk to the prosecutor and try and resolve the matter. It's a probable cause conference. If it can't be resolved on that date, you're entitled to a hearing. Let's call the preliminary examination. That's set for March 29th at 2 o'clock in the afternoon before this court as well. On those court dates, sir, will you be able to hire your own attorney, or are you requesting a court-appointed attorney?
No, sir. I have a very bad
At
cocaine
this
problem.
time,
I
I'm going to
cannot.
request a court appointed, if I could, Your Honor.
You raise your right hand, please. You swear or affirm to tell the truth with respect to financial questions the court's about to ask.
Yes, sir.
You put your hand down. Thank you, sir. Sir, I see you're employed full-time at EAD Construction. How much do you bring home and take-home pay on average per month?
It was part-time and I had just started working for them the day I got pulled over.
Vicky, we'll jump over there in a second.
Okay, very good. Do you have any money saved up in a checking or savings account or anywhere else?
He got
No, I do
fired
not.
on his first day because he's part time and got arrested his first day working
To
there.
sell to retain an attorney.
I do not.
My Jeep,
Any other property, sir?
no, sir.
The court finds you qualified for a court-appointed attorney. The court's made that, granted that request, and the bailiff, he's filling out the paperwork right now. That attorney will be in contact with you in the near future.
Oh, I didn't even see that.
Court date, all right?
Look at this
Yes, sir.
tattoo.
With respect to bond, Ms. Rucka?
Thank you, Your Honor. We are requesting the court consider a PR or low cash bond for
like
Mr.
to
St.
get
Bernard. He is a lifelong Monroe County resident. As he indicated, he is employed part-time, although he had just begun that.
Can I clarify this, Creed? This guy who got pulled over his first day at work and had cocaine on him.
Yeah.
At work.
How do you
his
expect to
first
get through
day-
your first day of work? You gotta have that.
Your Honor, it was a long day.
That job.
Probably.
His criminal record, he's had
Real,
no
yeah.
convictions in the last 6 years. I would note that the bond report indicates he does
Michigan.
have a bench warrant out of a circuit court, Judge White's court. I did discuss that with Mr. St. Bernard. He had informed me that he had retained an attorney here in town to address a probation violation. Approximately a year ago, he was under the impression that that matter had been resolved. If it has not, then of course he will need to address that. But we are asking for consideration for a PR bond with any condition that the court deems appropriate.
Okay, very good. Purpose of bond, sir, is not to punish you, but it is to make sure you show up in court and also to protect the community. I would note that you do have local ties to the community. Appears that you do have some employment. You have one known prior absconding that Ms. Rucka just mentioned.
20 grams, I
The
think they
warrant
said.
for absconding from probation out of the circuit court here in Monroe. Does indicate that you do have an opioid abuse problem years ago. You've been through inpatient, outpatient. Your last conviction was in 2016 for possession of controlled substance, second offense. In this matter, there was a traffic stop. Appears that there was a straw found in your left coat pocket. It had powdery substance or residue on it.
Oh.
We're just going to do this.
It was a pixie stick, Your Honor. Is it me or is Mr. St. Bernard getting lower and lower?
bond.
He's like Knox when he ends up,
the following conditions.
he's hunched over it.
Conditions are, number one, that you report to pretrial services if you're able to post bond. In order to appear for all court appearances on time, in order not to leave the state of Michigan without permission of the court. You're not to commit any crime while out on bond. You're to notify the court immediately in writing of any change of address or telephone number. You're to make all reports starting with that contact with pretrial services, and the jail will give you that contact information. You're not to use, possess, consume alcohol or any other illegal controlled substance. You're to participate in a substance use testing or monitoring program. Of course, it's going to have a GPS tether attached if you do post bond in this matter. Court orders that you do not possess, purchase a firearm or any other dangerous weapon.
He looks dead inside.
Participate in a substance use testing program or substance abuse. Those are the conditions at this time of bond. Ms. Rucka, any questions?
She's
No,
gone.
thank you.
Oh,
Mr. St. Bernard, any questions?
No, sir, thank you.
Okay. For this afternoon, thank you.
Who let the dogs out, Creed?
taking it back to Kansas, where
Judge Webster presiding from the trailer.
Yeah. I'm not sure what they're doing. I think that it's a small claim. Yeah, small claims.
Who's popping the back there?
Check myself on that.
And there was never a certified letter to come to me when he told you that he sent me a certified letter about this vehicle. There was never a certified letter. It was all through text.
Should her mom be allowed to be the judge?
Well, I was going to say, look at the sniffing that I believe Jesus Christ in the background is doing at the Glade.
Free Basin. Glade as we speak.
Do you want to jump over to...
Yeah, I'm pulling it up right now. We ready when you are.
Bit of a hoarder. Yeah, I just want to show you this one. I would imagine this is going on for a while.
I'm very happy to see that it looks like all of the young people over in Judge Porter's court are maskless nowadays.
His mother,
100% maskless.
Yes. How long has this been going on between the brothers?
For a very long time, many years.
Why do you think the most recent fight occurred?
DeAndre just wants to
They're both assholes,
have
Your Honor.
everything his way. If it's not DeAndre's way, it doesn't happen, or he gets aggressive.
Is there a big size difference between DeAndre and his brother?
Gooch.
I mean, his brother's a little more chunkier than he is, but
What about height?
Chunkier.
not too much.
Okay.
Chunkier, Your Honor. That medical term?
What steps have y'all taken to intervene?
DeAndre has been Tarrant County MHMR system, Child and Family Guidance Center in Dallas. It's just now that he's a little older, he kind of refuses for appointments. So we're just kind of stuck because he refuses.
When he refuses to go to his appointment, like you're getting in the car, you're getting ready to drive him, he refuses to go, what do you do in response?
I mean, he runs off. But here lately, it's been, most of it is all virtual. And so
Okay.
he just leaves. He's not he doesn't present himself. Even when I tell him the appointment is this time, you got to be here, he's gone. And
There's
so
almost
they just
100
kinda
people.
stopped.
Please like this
They
video
stopped
real quick.
setting
Thank you.
appointments because he's never available.
Okay, and so he runs off. Does he eventually come back home?
He always comes back home. Sometimes he stayed
Just
out
like my
overnight,
cat.
but most of the time, I mean, he comes back the same day, usually late that night. Sometimes it can be the next day. It just
Yeah.
depends if he has somewhere to stay or not.
On the
Does he
fly.
call you to let you know where he's staying?
No.
So I guess he either doesn't care or he's intentionally letting you stay up all night wondering whether he's alive or dead in a ditch somewhere because he couldn't be bothered to call you. Is that correct?
Sound like
Pretty
they're
much.
dead in the ditch.
Doesn't that sound kind of selfish to you, Mom?
Very.
And let me guess, this probably occurs on a night when you got to go to work the next day.
Always. It's typically I'm away from home.
And
Is when it
so the very next day, you're struggling at work, trying to focus on whatever you're supposed to be doing at work because you didn't get enough sleep the night before because you were up worried sick about him because he's too thoughtless and selfish to call you, correct?
Yes.
Meanwhile, you're at work trying to provide a living, a safe place for him to live, clothes on his back, food for him to eat. Again, sounds like he doesn't appreciate everything you're trying to do for him.
Not at all.
And sounds like these
what's his
appointments
excuse?
that you've been making.
If
for
he
him,
doesn't have a phone, that's his excuse.
part of an
you
effort
know?
by you to get him
I
help and help him do better in life and become a responsible young man, right?
Yes. I just wanted him to be successful in life.
Sounds like he doesn't appreciate that either, does he?
Got a long way to go.
Mr. Lofton, what are your thoughts? Do you have some questions for Mom?
Your Honor, we don't have any questions for Mom. We obviously have an alternative theory about some things, but we respect the decision of the court.
I'd love to hear
in all
it.
due respect. So
Now, Mom, in all fairness,
my friend.
this couple of years of fighting,
Creed frame, judge frame.
it's not 100% DeAndre's fault. I'm guessing the little brother kind of knows what buttons to push too, right?
Yes.
But in this case, you got a 14-year-old picking on a 12-year-old and pursuing him into a bedroom. Is he skipping school too?
He skips school.
I don't know.
More frequently, though, he's suspended from school than he skips.
Oh,
is he suspended for fighting?
No, it's usually just behavior. What he refuses to do. They've asked him to take his hoodie off. He doesn't. They ask him to not wear a bandana. He won't take it off. Or they ask him not to play music in class. He just keeps playing it. Or he goes to school and just doesn't go to class. He walks the halls all day.
Sounds like the kid needs to be locked up for a while then.
Yeah, I think he's good where he's at. Let's leave him there, Judge.
DeAndre, it just sounds like you're a little out of control. And it sounds like you need a wake-up call. Not everything in life allows you to get to do what you want, when you want to do it, and how you want to do it. Your mom, Judge Porter, Mr. Lofton, we all have rules we have to follow. Sometimes we don't like the rules. Sometimes the rules are stupid, but the rules are the rules, and we have to follow the rules, even when we don't like them. Same thing applies to you.
Hello, Mello.
You don't have to like the rules. I can't make you like anything, but you do have to follow the rules.
All right.
And your mom
see where
sets
that's
the
going. I
rules
want to go
for
back to
your home.
Kansas, see something different. I'm not sure who this is or what's going on, but let's check it out. And we'll come back.
That's my notes as well, Your Honor. I know my
What?
call on Friday.
They attack somebody in the locker room?
Mr. Watts.
Your Honor, Ms. Richardson
I was
called
gonna
me
say,
early
what's
this morning shortly
adult
after
film shoot?
about 8 o'clock.
And
was concerned about missing her court date on Friday. She didn't realize.
By the way, I love the dude's pro gun stance there right behind him. Can't miss that. But this girl, is there any reason why, like you said, in the locker room, why she needs 3 popo with her?
Armed and dangerous.
Correct that mistake and get herself back on the docket as quickly as possible. She's not attempted to run. She's not attempted to take off. She's not a flight risk. She wouldn't be here at the Sally Port in person.
I don't know what she
was a
did.
Flight risk. We'd ask the court to consider setting aside the bond forfeiture bench warrant. Her current bond was $1,500 cash or surety, and reset this case on a pretrial docket in front of Judge Hart. I will tell the court I contacted Ms. Norris this morning after I was contacted by Ms. Richardson to make sure I always contact county attorney's office before I call a judge to make sure I don't do anything ex parte. But I also contacted Judge Hart's office after that and learned that Judge Hart is at this point winding his way to the lovely state of Hawaii. So he is not available to make a decision as to what we should do on this.
Not sure, but
Why is the attorney
To
look like
withdraw the
she's
bond
12
for
years old?
Place her, she is set on at that time, it was set for a pretrial docket. And
She's the
already
assistant to the
waited in there
assistant of the
hearing.
county.
I think this case will ultimately resolve by plea in all likelihood. So would I urge the court to withdraw the bond forfeiture bench warrant.
Thank you, Mr. Watts. Ms. Booker, state's position.
Your Honor, I guess the state doesn't have a strong position one or the other. It's a judge's order of a no bond hold. I understand Mr. Watt's position with Judge Hart not being available.
Stephen, that's why I jumped over on to see if something crazy going on.
Treatment program. I'm not sure if that was successfully or unsuccessfully, but it's obviously concerning to see a note, I guess, from an attorney from that previous hearing. Additionally, I don't know really, I guess, what the definition, how you would define immediately. The court hearing was Friday at 9 a.m. and there wasn't contact made until Monday. So they had all day on Friday. I'm not sure what the defendant was doing, but it's important, obviously, to keep court dates, as the court said
She's
earlier,
got some
in other hearings,
attitude.
to keep cases moving along. I agree with Mr. Watts, said a pretrial setting. So there's no, I guess,
She has a lot to say. I hope they just let her
excuse
go.
me, no
Ms.
prelim pending.
Richardson, please don't interrupt.
There's no prelim pending at this point, so it's just pretrial awaiting jury trial. And obviously, we understand what the jury trial schedule is right now. It's about one a month until the court opens.
Is she
So I
going
would
for a
leave the
jury
court's
trial?
Discretion,
That'd be
one way or
good.
the other.
Come on, what did she do?
All right. I have word from Judge Hart's office that he doesn't object to withdrawing the bond forfeiture bench warrant. So I'll do that at this time, being that she, well, I wouldn't say immediately, but within one business day, contacted your office, Mr. Watts, and appeared here before the court. I'll reinstate the previous bond that was in place. I don't have all the information on
Yes,
what that is, but that will remain in place, and I can set this back in front of Judge Hart on April the 8th at 9 o'clock in the morning. If that
Did they
works.
pull her off of the basketball court to come
That's
in here?
his pretrial plea docket.
Played some b-ball.
Oh,
Yes, sir.
she's
And
got
Ms. Richardson,
everything at her disposal.
You are at this point literally about a block from my office, or a block and a half. Would you come by my office immediately, make sure we have good contact information?
Yeah, so I'm not going to jail, am I?
No.
No? Okay, and Your Honor, I just want to vouch and say I work at 9 to 5, and I was working in Wichita on Friday, and then Monday to Thursday, I work from 7 a.m. to 2 p.m. So that's the only reason I missed is because I had court the day before, and I got my days confused, and I was at work. And I have, I can have paperwork facts to my attorney to prove that I was at work and that I'm working a job.
But that's not necessary at this time, Ms. Richardson. Just make sure that you
Her speaking was like, I didn't expect any of that right there. She looked like she was ready to blow
Like I did
up.
unsuccessfully complete treatment. I left.
Miss Richardson.
I did
That's something we need to
unsuccessfully.
address today.
How about you
Okay.
just be quiet, Miss Richardson? They're letting you go.
All right.
Ms. Richardson, do you know where my office is?
You said shut a block away. Which direction?
I am at 218A West Central.
Okay. What is
You
the
know
option?
that great big old courthouse that you saw as you came into town?
Uh-huh.
I'm directly across the street from the front steps.
All right, we'll end over here with what do you got?
Possess a weapon of any type.
I
or
don't
any
know, but I
imitation
saw
thereof,
Michael
any
Young here
ammunition,
and I had to
or any
stop.
firearm
What
components.
is
I'm also
that?
adding an additional condition 19, so the council wouldn't have had an opportunity to opine or comment on this. I am adding it, however, today. Mr. Young, I don't know if you have a problem with drinking. I don't know if, in fact, you were drinking at all this day, but some of the allegations
Correct.
surrounding this case are that you were. I don't know the answer to that. But I do know that, you know, this situation occurred and I want to do whatever I can to address
back brace.
a problem should it be there. So I am ordering that when you are not in custody in the Washtenaw County Jail, that you attend AA or another probation approved program 5 times per week for the first 6 months of your probation, and then thereafter 3 times a week for the balance of your probation. Again, I want to be clear in why I'm doing that. If you have a problem drinking, sir, this is a time to take care of that. If that's the case, it obviously resulted in some serious impairment of your life, if that's the case. If it's
Really
not
might
the
cry about
case,
it.
you're expecting the birth of your first child. We are trying to deal with this issue. And in the event that that is even on your horizon, I do want to do what I can to try to offer something constructive. If this is just a big waste of time because you actually don't have a drinking problem, then I'm sorry for that waste of your time, but it will not last forever. It's only 18 months. So to the extent that I can offer any comfort to Ms. Vitale's family as it relates to that sentence, I want you to know that I have heard you and I have read what you have written, and I am compassionate in the amount that I can be, to the extent that I've addressed, what I keep referring to as a constructive sentence for you, Mr. Young, that takes into account your remorse and your sorrow as expressed today, your obvious physical issues that are today, as well as hopefully something constructive going forward.
You must have hurt somebody in a car accident.
I want you to know that I do think about these things, and I have done that. There is a provision, Mr. Young, that if you serve half your probation and complete the required programming, you may be eligible for early discharge. Your probation officer, or you could petition the court for that. You would have a hearing on that, and I would, engage in that discussion at that time. You should also note that you'll be provided an appellate rights form. In this case, because you are pleading or you pled, you have the right to file an application for leave to appeal the court's decisions, and the form explains that. The important thing is that if you wanted a court-appointed attorney, you would have to ask for that in writing within 42 days of today's date. So Mr. Simon would be able to get that form to you, and he will do so. As it relates to your reporting to the Washtenaw County Jail, it's Monday afternoon, sir. You're sitting there in a brace, and I understand. I guess what I wanted to ask you is, do you have any pending medical appointments in the next couple of days, or can we just get this part of it done right now?
I do, but I'm willing to. One, we've been waiting to get in for a while, but just go in and get it done. I don't know.
I'm going to have you report by 5 p.m. tomorrow afternoon to the Washtenaw County Jail. Then.
Right in tonight, is that okay?
Well, on or before 5 p.m. tomorrow, so that you can talk to Mr. Simon about other options. But okay,
he's ready to start doing some time, baby.
Yes, I'll take care of that, Your Honor. Thank you.
Speaking of doing time, Mikey, we have done our time, and it is
closing time. Yes, another great time here in the courtroom, Creed. If you're not like these other people and haven't liked these videos, please, wherever you're watching, do so. We do have a all case channel now. It's called We Got a Case.
23 likes and like 30 something subs.
Hey, good stuff. We're glad to hear it. We're going to be back with Mini Chase Monday. Some really good chases. Lord have mercy. Coming your way.
5 days a week.
We also have a Facebook now group, Chases and Cases. If you want to look that up and join that, we're going to be doing some stuff over there. Anything else, Creedence?
Thank you, Jonathan. No, and I tried to do some slot streams, but we had 5 hours or 6 hours of no power the other day, and then birthday yesterday. So that was it. We'll see you at 4:05. Love doing We Got a Case. We'll be back again, I would imagine, 1 o'clock tomorrow for another round of We Got a Case. And yeah, excited having We Got a Case YouTube channel and build that up. And for any of you that don't like all the other stuff that we do, just like the We Got a Chase channel, it's the same thing. You can kind of separate it out and don't have to worry about all the other stuff. Mello, good to see you. Thank you guys for hanging out. And we'll be back, less than an hour now.
That's right. All right, you guys, remember, hard work pays off, dreams come true, bad times don't last, but bad guys do.
Too sweet.